Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Let's get to the docket. First, the E word is being thrown around in the Lori Vallow, Chad Daybell matters. That's right, ethical. Second, an update on the Alec Murdaugh case. Third, Elaine Maxwell, her trial continues. Josh Duggar's trial continues. Jussie Smallett gets a little snappy on the stand on cross-examination. Is there a break in the Delphi murders? We'll have to wait and see. And then finally, the dumb criminal of the day. Let's talk about it. It is Tuesday, December 7th, 2021. We have a big docket for you today, but hey, you know the drill. If you like the video, hit the like button. If you haven't subscribed, please hit the subscribe button. And as always, hit that little bell so that you receive notifications of when we go live and put up new content. As a reminder, our Tuesday night live will not be up tonight. We're going to do it tomorrow night because I have to travel to the Western Slope and it's just not going to work out very well today. So I appreciate you accommodating that schedule. Let's get to the docket, okay? There's been some new filings in the Lori Vallow, Chad Daybell matter. As you may recall, Mark Means has made some pretty significant allegations, basically stating that the people that are trying to restore Lori Vallow to competency somehow are trying to influence her into obtaining new counsel, and apparently provided the information to call the attorney for the Church of Jesus Christ of Latter-day Saints, aka the Mormons. Well, Mark Means filed a motion a couple of weeks ago, and he wanted subpoenas, you name it. It was completely, I think, outrageous. It's called Do Your Own Investigation. What authority, if any, does Mark Means or the courts in Idaho have in Utah? Well, little to none. Well, the Mormons, the Jesus Christ of Latter-day Saints, they filed their responses. It's basically a motion to quash or modify the subpoena. And basically they're saying, hey, the information that Mr. Means is requesting is either A, privileged, or B, not relevant. And some of the information that they have, the Mormons are basically saying, we're going to allow the court to review it in camera, which simply means the court will review it and see if there is some relevance to the case and whether it should be produced or not. Now, what the judge will do in this particular case, I am not sure, but I hope that somebody puts the hammer down for sure. Mark Means also filed a response to the motion, which basically is that Mark Means should be held in contempt for basically doing lots of things that they consider to be unethical, that the prosecutors consider to be unethical, by making allegations, not backing it up, not conducting any investigation whatsoever, and basically just laying out untruths in his motions. And the prosecution also basically said, hey, Mr. Means isn't really qualified to handle this case, hence the reason why the court appointed on its own motion a death-qualified attorney, a guy by the name of Mr. Archibald. And as you've noticed, Mr. Archibald doesn't join in any of the pleadings filed by Mr. Means. Well, I think we now know why. All right, so in the defense motion and objection for contempt, basically Mark Means says that the prosecutor, Mr. Wood, is a witness and that he is unethical, and cites once again to the conversations that Mr. Wood has had with witnesses in this particular case. Now, it's old news. It's a transcript that took place with other witnesses of basically family members of Lori Vallow. I think what is rather interesting is that in paragraph 5 of the motion, Mr. Means states, furthermore, this is an attempt to continue to drive a wedge between co-counsels in the defense of Lori. This court, sua sponte, appointed Mr. Archibald as a death penalty counsel in a case in which no death penalty notice has been filed in this matter. The court appointed Mr. Archibald as co-counsel, and it is self-evident, and there are competing theories of defenses and avenues of advocacy or Lori as illustrated in this matter. This conflict is a direct assault on Lori's right to counsel of her choice and unnecessary interference to her rights to a unified defense imposed solely by the court. Wow. Basically what that means is that Mr. Means is saying the court is sabotaging his relationship with his client by appointing a qualified criminal defense attorney on the case. Pretty bold allegation indeed. I'm not sure you want to say that unless you can actually back it up. The court did, in fact, appoint a death qualified attorney, Mr. Archibald, which means he's done the requisite number of felony trials and knows how to engage in defense mitigation, whereas Mr. Means has never tried a felony case. The court did that because everybody and their brother knows they're going to go death. And they, being the prosecution, is going to go death as it relates to Lori Vallow. They've done it for Chad Daybell. They're going to do it for her as well. And either way, even if the prosecution didn't go death, she still needs a qualified criminal defense attorney, not some guy that was basically doing divorce law and somehow this case winds up on his desk. He's out of money. He gets court appointed. The court appoints somebody qualified and he's complaining. And he basically says there are different theories of defenses and the defense isn't unified in how they think this case should be handled. Well, Mark Means, I would think I'd probably defer to the more experienced criminal defense attorney in this regard, because in all honesty, you've screwed up just about everything that you've touched in this case, and it's just a little weird how attached you are to your client in this particular case. How can you be sure that she wants you as an attorney because she's not competent? And it maybe took you over a year to decide to question that competency. I think you should sit back and probably defer to Mr. Archibald on this. And yes, start carrying his briefcase. All right, next on the docket, an update on Alex Murdaugh. Remember the attorney there in South Carolina? Well, it's been nearly 3 years since Anthony Cook and his girlfriend, Mallory Beach, were in a fatal boating accident, allegedly driven by Paul Murdaugh. Now, Cook has now joined the ongoing legal battle against Paul's father, Alex Murdaugh. And as we know, Mallory Beach was thrown from the boat that an intoxicated Paul Murdaugh was allegedly driving. Now, Paul, who was murdered in June of 2021 alongside his mother, Maggie Murdaugh, was facing 3 felony boating under influences charges at the time of his death. Now, on Thursday, Cook filed a personal injury suit against the following parties: Gregory M. Parker, Inc., Parker's Corporation, Parker's 55, Parker's Kitchen, Taheha Cohen, and Alex Murdaugh. Anthony Cook is being represented by Patrick Carr of Carr Legal Group on Hilton Head Island and Beaufort, South Carolina. The Parkers and Murdaugh are already facing 2 other lawsuits in the February 24th, 2019 fatal boat crash, one from Mallory Beach's estate and one from Anthony Cousins, Connor Cook, who was also injured in the crash. Now, Anthony Cook accuses Murdaugh, the owner of the boat, of negligently entrusting the boat to Paul, who was known to have had dangerous drinking behavior and boating tendencies. The lawsuit also states that Alex Murdaugh not only knew about his son's proclivity for underage drinking, but he was also aware that Paul used his older brother's driver's license and his mother's credit card to illegally purchase alcohol and in turn consume the alcohol to the point of intoxication. Now, the lawsuit repeats that Alex Murdaugh condoned Paul's excessive drinking and careless driving. Cook's lawsuit says that Parker and Cohen, the cashier who sold the alcohol to Paul that day, would have known an illegal alcohol sale was occurring had Cohen's followed Parker's corporate policies, which would have triggered further inquiry or investigation into the transaction. The lawsuit notes that this was not the first time these defendants had sold alcohol to an underage customer, and that Parker's has also sold alcohol to customers who were known to be already intoxicated or drunk. And that's a violation of the law in South Carolina. Now, although Parker's has policies and procedures related to safe alcohol sales, Cook's suit says Parker's routinely violated these policies and state law because they are more concerned with the speed of the customer transaction and the financial profits to realize from alcohol sales rather than the safe and responsible alcohol sales. So, lesson to be learned here, ladies and gentlemen. When the clerk IDs you, just give them the ID because, you never know. You could be somebody out there buying it for a minor with a fake ID or that of his brother. The next thing is parents. Everybody thinks it's cool. Oh, I'm going to be the cool parent. Let everybody drink when they're underage. Yeah, don't do it. That's why Alex Murdaugh is getting sued. He condoned this conduct, and there's pretty good evidence out there that he knew his son had a drinking issue and became the bad Paul Murdaugh when he drank. You can't do it. Don't be the cool parent. Part of the job of being a parent is to be a parent, not to be the cool one by saying you can do whatever you want. And guess what? When you get sued, when somebody dies, and somebody seems like they always die in situations like this, that's at least when it gets highlighted, they're going to take everything you own. So just remember that. Just remember that. Now, in some other Murdaugh news, the attorneys representing Gloria Satterfield's family have made a jaw-dropping amendment to their lawsuit versus Alex Murdaugh. The amendment accuses Alex Murdaugh of paying his co-conspirator, Curtis Eddie Smith, more than $1.8 million from fake bank accounts since 2015. The amendment also adds Bank of America as a defendant, calling on them the bank of money laundering. Attorney Eric Bland and Ronald Richter say the Bank of America allowed Murdaugh to launder huge sums of stolen money by flexing its own rules and ignoring bank customs. In the lawsuit, Murdaugh is accused of writing 254 checks to Smith between 2015 and 2021. Now, according to the lawsuit, Murdaugh used a Bank of America account under the fake business to issue 17 cashier's checks totaling $164,000. Murdaugh opened up 2 fake accounts with Bank of America. The first account was opened on September 22, 2015, under the name of Richard A. Murdaugh, sole proprietor, doing business as Forge. The second was a business account opened under the name Forge on August 15 of 2018. Bank of America is a bank of fraud, this lawsuit alleges, and the bank chose to help Murdaugh cash in on his crimes. Now, the virtual bond hearing on Murdaugh's new 27 allegations will be this Friday at 9 a.m. We will try to be watching if we can. And just to follow up, Alex Murdaugh is being sued for negligent entrustment because he knew that his son was out drinking, okay? Little different than the situation in Michigan where there's some evidence that, yes, they bought their son a firearm, but they didn't know that he had it with them at school. That's why I got a little bit of blowback yesterday on some people saying, no, the parents should be charged. Hey, they have been charged. I'm just not sure when you read the jury instructions whether they're going to be able to make that case, but we'll have to see. I also received a couple of people who were rather upset with me and said that if I offend anyone, I shouldn't say anything. If one person is offended, then you shouldn't say anything. And I responded back to the person. I said, basically, that's the dumbest thing I've ever heard. No one has a right not to be offended. And when you think about today's world that we live in, where so many people are offended by anything, some people are probably offended by me talking about people that are offended. Think about it. Here we are on the 80th anniversary of World War II, or the start of World War II, really, with U.S. involvement because of Pearl Harbor. I mean, those young men and women, obviously, who went to fight, who charged machine gun bunkers, do you think that they were concerned about getting their feelings hurt? And it all starts because people are more concerned about not having their feelings hurt than the truth being told. I just don't get it. All right. Speaking of the truth, let's talk about Elaine Maxwell. Prosecutors have shown new photos taken by the FBI from the 2005 raid of that man named Jeff. That's right. We can't say his last name because, well, YouTube will shut us down. And that raid was at his Palm Beach mansion and the 2019 raid of his Manhattan home. Now, U.S. District Court Judge Allison Nathan denied a request by Maxwell's attorney on Monday to bar the photo, which the FBI agent found on a compact disc seized from that guy named Jeff's Manhattan home during a July 2019 search. So far during Maxwell's trial, several witnesses have testified that they thought the pair was in fact a couple, while others believed that it was basically a business relationship. Prosecutors have tried to characterize them as being true partners in crime, and one of the photos included a table full of picture frames, which you can see photo of the couple passionately kissing. And the judge admitted one of the photos of an accuser, which depicts a woman whose case is not included in the indictment as evidence. She stated that she would possibly consider others photos being admitted if those women, in fact, testified. Now, a woman under the pseudonym Kate testified that several of the photos shown to the courtroom included Maxwell and that man named Jeff smiling together, Maxwell rubbing Jeff's feet, Maxwell in a bikini on a boat, and several more never-before-seen photos, which will be available to the public later in the week. Now, several pictures of the massage room where several victims claim that's where the abuse had occurred was also shown, and the picture shows shelves of lotion and oils along the wall. Some of the pictures have pieces blacked out, which some are speculating could be some of photos of naked women that that guy named Jeff would keep around his house. This was the room that Jane testified that she had been abused in, and one of the photos shows Jeff's bathroom and what appears to be a safe in the middle of the floor, as well as a large amount of currency and several passports. Now, perhaps one of the strangest photos is a photo of Elaine Maxwell and the man named Jeff meeting Pope John Paul II at the Vatican roughly 20 years ago. Photos showed his bedroom and a bathroom equipped with a fully equipped dentist chair and the massage table that the accusers claim were actually used to give him sexual pleasure. Maxwell's defense attorney, Laura Menninger, who said some of the photographs could have been altered, she argued that the prosecutor should have shown the photographs while Kate was on the stand to give her the opportunity to authenticate the photos. And in all honesty, that's what is in fact usually done. You have to have a witness testify that that is a fair and accurate representation of the photo as it appeared. It gets a little trickier when you have somebody testifying as to photos that they just found there. Gets a little tricky for the record indeed. Now, the other accuser, going by the name of Carolyn, took the stand the other day and testified that she had been to the man named Jeff's home more than 100 times, 2 to 3 times a week from the age of 14 to 19. Now, Carolyn, that's her first name, said that first time she went to the house, she was just 14 years old, and that Elaine Maxwell greeted her at the door. Maxwell apparently came in and felt her breasts. According to the witness, she told me that I had a great body for that man named Jeff and his friends. She added that Maxwell took pictures of her in the nude. Carolyn also testified that Maxwell took off her clothes and began to massage Jeff's back for about 45 minutes. He turned over and Virginia Roberts began to have sex with him. Carolyn said that she's watched from the couch and was given $300. Carolyn testified that she only got to the 7th grade and that her mother was an alcoholic, that she would go back to the home to earn $300 per week. Now, obviously, the prosecution's theory is that guy named Jeff had targeted young girls from broken homes who would be easy targets and less likely to go to the police. Sound familiar? Sounds like grooming, doesn't it? Well, Carolyn said that Miss Maxwell asked for her phone number. When she would call Carolyn, she would ask if she'd be available if that guy named Jeff flew in. They asked her to travel overseas, according to Caroline, and she said that there's no way that her mother would okay that. Carolyn said that she told everyone that she was 14 years old. She also testified that Miss Maxwell was the one that handed her the money. Specifically, Miss Maxwell would give her 3 $100 bills. Carolyn also testified that she would be sent lingerie, concert tickets, and a book called Massage for Dummies. Carolyn then admitted to bringing friends to Epstein's home, including 3 girls named Amanda, Tatum, and Julie. She alleges that she was asked to bring young people, and she told the court that I don't hang out with young people, so that she really wasn't anyone she could ask. But when she didn't bring somebody, she got paid $600 and the other person got paid $300. She described how that they would engage in sex with that guy named Jeff, and that she really didn't get invited back to the house when she turned 18 because that guy named Jeff considered her too old. Well, it makes you wonder, doesn't it? Based upon some of the people's argument yesterday, where were the parents for these young ladies? Now, obviously, they were in a situation where, as Carolyn testified, her mother was a drunk. She had a 7th grade education. She needed $300. Her mom's probably not going to get the Mother of the Year award, but, under our legal system, we usually don't hold somebody else responsible unless they actually engaged in conduct and supported it. All right, next on the docket, Josh Duggar. The trial continues. Now, after the prosecution in the Duggar trial rested, the defense called their own analyst, to build an alternate scenario of what happened back in 2019. The forensic examiner, a woman by the name of Michelle Bush, described a parallel and sometimes contradictory set of facts from the analysis of the prosecution's main expert from the Department of Defense. Now, as you may recall, the prosecution's expert testified links based on Duggar's iPhone photos and text messages and the downloading and viewing of the sexual abuse materials at the work computer at Duggar's wholesale motor car lot. Well, the prosecution expert said that someone would had to be physically present at key points in using the work computer, such as installing and then switching over to the separate Linux system on the computer that had its own password. He said in a preemptive rebuke of the defense that he did not see a pattern of remote access on the work computer that would have left Duggar as an unwitting target rather than the perpetrator. The prosecution expert noted that the password for the computer separate operating system where the illicit materials was found matched a password that was used ubiquitously by Duggar for his personal accounts. Now, the defense expert in her own testimony Monday pushed back on some of the government's experts' conclusions. Ms. Bush testified that she could not rule out remote access, and she stated, "The evidence leads me to believe that a very viable possibility existed for remote access." Now, Bush said that she was leaning toward the theory of remote access based on three factors. Now, one of the agents had testified that the streaming in this instant was something of a misnomer. It would have been easy to do a copy and paste of the link from the downloaded program onto the video player that didn't actually refer to watching something from a website like Netflix. But Bush cast the decision to stream the download files as something more bizarre and said it indicated that the videos could have been accessible to outside users via the router, even though the router essentially then sent the videos back to the work computer. Now, Bush said that she noticed the router's ports or specific references of the internet activity were changing as the videos were being viewed. She called it port forwarding, and it could, in some cases, be used to mask the true user. She said that's a pretty sophisticated level to hide your activity. She stated that the universal plug and play had been able by the work router, which Bush said created external weaknesses in the network. She said that setting is often used for home networks to make it easy for the devices to find another. But there are also vulnerabilities because it assumes all the devices in its close proximity are trusted. Now, she made further rebuttals of the government's testimony last week and said it was possible to remotely boot a computer and, depending on its settings, access the settings operating system installed there. And the Dell One username for the separate part of the Duggar office computer where the sexual abuse material was found could have been auto-assigned by an outside application. Some of the applications used to obtain the inappropriate images were likely manually installed via command lines. Now, what does that really mean? It means that the Duggar case, the Duggar defense, is based upon somebody else could have done it. It's a battle of the experts. The prosecution experts are saying that Duggar was behind the computer. Remember, the prosecution has to put Duggar behind the computer downloading those images. Not somebody that looked like him, not someone that accessed the computer, but that it was him. The defense is clearly trying to raise reasonable doubt that basically Duggar's computer was hacked and somehow used as a storage device for these inappropriate images, whereupon the real perpetrator could access them for viewing at a later time. We will see how much credibility the jurors give to these expert witnesses based upon the information that was found on the computer. And Mr. Duggar, I think the biggest question he has to answer is, how did you know the police were there about the images downloaded on your computer when they hadn't told you why they were there? Okay? It's always the defendant's own words that come back and bite them. I think that may be the deciding factor in this particular case. Next on the docket, Jussie Smallett apparently doesn't like to be questioned. Yep, that's right. As you may recall, Jussie Smallett took the stand again in Chicago for his trial, where he was accused of obviously lying to the police about being the victim of a hate crime back in January of 2019. Now, he told the jury that he first called his attackers white, then changed the description to pale. Smallett also said he had just assumed they were white in his first description and claims he still doesn't know who actually attacked him. Now, obviously, Smallett became increasingly defensive while taking the stand, snapping at the prosecutor when he used the N-word while reading aloud text that Jesse Smallett had written, insisting he has permanent injuries from the incident. Now, during cross-examination by the prosecutor, Dan Webb, Smallett became exacerbated and snapped, telling the jury and the judge that he didn't want to answer yes or no to the questions and that he has scars on his face that will be there for the rest of his life. Well, ladies and gentlemen, remember, cross-examination, good cross-examination is done, and the answers are yes or no. That's it. On redirect, you can have your attorney ask questions to clarify, but a good cross-examination, the answer is simply yes or no. You don't get to have a rambling dissertation of what's taking place. Now, Mr. Smallett also said that he didn't want to make any assumptions that they were white, being the attackers. So he said, let me change that. Just say that they had pale skin. He said it was the responsible thing to change the description because he couldn't be sure. They could have been white person, they could have been pale or something else. When asked if he described them as white because he thought it'd be more attention, he snapped back, "You have to ask somebody who actually did a fake hate crime." And I'm sure Mr. Smollett's attorneys told him, don't get snappy on the stand, be polite. If there's a problem, we'll come back and clean it up on redirect. Getting argumentative, not good on cross-examination. Mr. Smallett also would not say for a fact that the brothers were on the surveillance camera filmed near the area of attack on January 29th of 2019, despite previously claiming that it was them. Now, Mr. Smollett's attorneys in opening statement said that the brothers who attacked him, and they did it because they hate the person that he is. Now, the jury was also shown the interview of Mr. Smallett from February 14th of 2020, and Mr. Smallett said then that he had lots of makeup on to cover up the bruises and injuries, which he said he'll have for the rest of his life, and they're going to be a problem. Mr. Smallett insisted this was never the case because he hates attention, i.e. he hates the publicity around this, and he would never do something like this because he hates attention. He said on Monday that he would never have been involved, the police, because he just doesn't trust the police. Now, closing arguments are expected to begin tomorrow. Obviously, as soon as the verdict comes down, we will let you know. Is there a break on the Delphi murders? Well, Liberty Libby German, she was 14, and Abigail Abby Williams, 13, disappeared on February 13th, 2017 after heading off to the trails that crossed the Monon High Bridge over Deer Creek in the small town of Delphi, Indiana. Their bodies were found next day on the banks of the creek. Now, the girls took photos and posted them on Snapchat during their walk, and then on the bridge, Libby snapped a photo of a man approaching them. She changed to video and started recording, slipping the phone into her pocket where it recorded the man's 4 words, quote, "Guys down the hill," end quote. And later, it recorded both girls' murders. A fake social media account by the name of Anthony_Shots used the profile while communicating with juvenile females to solicit nude images, obtain their addresses, and attempt to meet them. Now, state police didn't say if they believe the fake profile Anthony_Shots is related to the murders, but it said detectives came across the profile while investigating what had been dubbed the Snapchat murders. The real person in the photo has been investigated and is a known male and is not connected with the investigation. Police now have asked anyone who may have communicated with Anthony_Shots to contact law enforcement and provide as much information as possible, including dates, what social media apps that they used, and whether the profile tried to meet with them and whether they tried to get their address. Hopefully there'll be a case in the Delphi murder. That one's super, super interesting. Next on the docket, our dumb criminal of the day. Please meet Mr. Jeremy Camperveen. He is 19 years old, and he has been arrested and charged with cyberstalking of a Florida state Democratic senator by the name of Lauren Book, after he threatened to send stolen and doctored photos of her. Now, police allege that Mr. Kemperveen demanded both $5,000 in gift cards and sexual acts from Ms. Book in exchange for not sending the photos to the conservative-leaning news outlets. Now, investigators managed to catch Mr. Kemperveen by assuming Ms. Book's identity on social media. The police then began communicating with Mr. Kemperveen and pretended to go along with the plot. Needless to say, didn't turn out well for Mr. Kemperveen. All right, that's all we have for you today. Thanks for watching. Remember, no live tonight. It'll be Wednesday night. Have a wonderful day. We'll see you next time on Crime Talk.